It's been an active couple of weeks with Second Amendment litigation both in the state of California and nationwide as we see the Supreme Court take up the Wolford v. Lopez case on sensitive places coming out of Hawaii, while we also see the Glock Ban Bill get signed by Governor Gavin Newsom and a pending lawsuit against that as well. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we've had some big things happen over the last week or so I thought it would be a good idea to touch on them at least a little bit. I know we did the live stream on Saturday and we touched on some legislation that was signed into law. We also touched on the Wolford case being taken by SCOTUS. That's the one that I wanted to dive a little bit deeper into today. So to walk us through that, we have brought back the CRPA volunteer president. That of course is Chuck Michel. Chuck, thanks for being on with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. And guys, before we get into today, as always, please be sure to like, share, and subscribe to the videos. It really helps get this information out there as far and wide as possible. We've done a great job in California this year with other organizations building coalitions to push this ball forward. We are winning the war, and it's taken a group effort to do it, and we want to continue to do that. So please be sure to like, share, and subscribe. It really helps get the information out there. So Chuck, I guess before we get into the Wolford case, I did want to get your opinion on this. Of course, on Friday we saw Gavin Newsom sign a few bills into law that look like they're going to be infringing on our Second Amendment rights. But the one that makes the news headline today is the Glock Ban Bill that he signed and the NRA lawsuit that appears to have been filed as well. Jacob, if you could pull this up. We got this from Fox News, and it reads like this. On October 10th, Newsom signed Assembly Bill 1127, which prohibits licensed firearms dealers from selling guns that can be easily converted by hand or with common household tools into a machine gun. Although the Glock isn't specifically mentioned in the legislation, it falls into that category of firearms. The Glock is infamous for its easy alteration capabilities by using a Glock switch. The bill's author, Jesse Gabriel, said an automatic weapons are exceptionally lethal and capable of firing hundreds of rounds per minute. They are illegal in California. Unfortunately, some semi-automatic firearms feature a dangerous design flaw that allows them to be converted to fully automatic weapons through the attachment of a cheap and easy-to-use device known as a switch. He added, sadly, certain companies in the gun industry have known about this issue for decades and have done nothing meaningful to address it. This common sense legislation will ensure that the gun industry is held accountable and that we're doing everything we possibly can to protect our communities from mass shootings. AB 1127 passed through the legislature with a vote of 58-17, garnering support from Democrats and opposition from all Republicans. After being signed into law, it's expected to go into effect July 2026. For Glock to continue being sold in California, it would have to undergo a stringent process of modifying its design to comply with the new state law. The National Rifle Association is fighting back against this new legislation. Our message to Governor Newsom is simple, the NRA said in a social media post. We will see you in court. John Comerford, the NRA ILA executive director, said Gavin Newsom and his gang of progressive politicians in California are continuing their crusade against constitutional rights. Once again, they are attempting to violate landmark Supreme Court decisions and disarm law-abiding citizens by banning some of the most commonly owned handguns in America. Comerford said this flagrant violation of rights cannot and will not go unchecked. And I got to tell you, my blood boils a little bit every time I see a comment about Assembly Bill 1127. And they kind of lay it out here. It's pretty ridiculous. You know, you have cars that are designed to go faster than the speed limit. It's still illegal to go faster than the speed limit. This is not this is not an uncommon thing with products that we buy. California already says it's illegal to convert a firearm into an automatic firearm. So why is it that they have to go after parts that would ban guns in order to make it more safe when it's already illegal? If anything, this should just be a truth claim that criminals don't abide by the law. That's the real problem. needless to say, I digress. Chuck, I guess what I wanted to focus on with you was the lawsuit that's been filed here. And we've talked a little bit about timing for lawsuits being filed. This is really quick. The NRA is getting out in front of everybody else here. I also saw a social media post from FPC about how they're involved with this as well. How do you see the progression of a lawsuit that's filed now for Assembly Bill 1127 when it was just signed into law a couple days ago and it's not going to take effect for about 8 months?
State will probably say the case isn't ripe yet. It should be, though. I mean, it's going to go into effect. It has been signed into a law. But the state loves to throw these procedural hurdles in the way to bog down the case and cost the plaintiffs money. But ultimately, the issue needs to be resolved. A Glock, it's already illegal to convert any gun to fully automatic. It's illegal to have the parts to convert a gun to fully automatic. And the Glock is one of the most common and probably the most common self-defense handgun and target handgun in the country, not to mention the state of California. Of course, you can only get, I think, up to Generation 3 Glocks on the roster now. So CRPA will be supporting the NRA, FPC, and Second Amendment Foundation in this case. We will do amicus briefs to get some extra information in front of the judges, and we're looking forward to helping them out. And in the meantime, though, might be possible for Glock to now get a more recent generation Glock on the roster that has some kind of a design change so that it's not the Glock switch won't work.
Yeah, that speculation has definitely been thrown around as this bill has been going through the process of ultimately being signed. So definitely something to watch from Glock there, but also there is a lawsuit that is out. CRPA will be supporting that in whatever way we can. And definitely going to be paying attention and probably doing some more videos on that one moving forward. But so Chuck, the reason why we wanted to get you on a call ultimately was to discuss the Wolford decision.
But don't forget, there's two other bills that passed. There's the 3 gun a month, and there's the ban on the sale of barrels. They're treating barrels like they're treating ammunition right now. Those are two cases that the CRPA is already pulling together to get ready to challenge. So there's more than one lawsuit coming out of the worst bills that came out of Sacramento this year.
Yeah, and we'll definitely be paying attention to those as well. I know we covered those on the live stream as well. So as the next step in the process of advocating for Second Amendment rights, which is the litigation once the laws are passed, starts kicking in, we're definitely going to be following up on those. But Jacob, if you could, Chuck, I wanted to get your opinion on this as we do see the Supreme Court of the United States, right when they get back into session, decide to take a Second Amendment case. Jacob, if you could pull this up. This is the QP report from the Supreme Court, and it reads like this. New York State Rifle and Pistol Association v. Bruen holds that the Second Amendment guarantees a general right to public carry of arms, meaning ordinary law-abiding citizens may bear arms in public for self-defense. In this case, the Ninth Circuit sustained a Hawaii law that makes it a crime for a concealed carry permit holder to carry a handgun on private property unless he has been given express authorization to carry a firearm on the property by the owner, lessee, operator, or manager of the property. That holding is in acknowledged direct conflict with the Second Circuit's holding in Antonic v. James, a decision that struck down the identical state law in the same procedural posture as this case. The Ninth Circuit also sustained a multitude of other location bans on carry by permit holders relying solely on post-Reconstruction era and later laws. The questions presented are: 1, whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to that handgun carrier, and 2, whether the Ninth Circuit erred in solely relying on post-Reconstruction era and later laws in applying Bruen's text, history, and tradition test in direct conflict with the holdings of the 3rd, 5th, 8th, and 11th Circuit. Of course, you can see there, guys, that the petition for cert was granted, but it also says it's limited specifically to question 1. So, Chuck, obviously this is good news, and for those who haven't been following along, This Wolford v. Lopez case was a very similar case to our May v. Bonta case out of California, but this one came out of Hawaii. In fact, they were both heard together at the Ninth Circuit, and I remember talking with you, Chuck, about how one distinction between the Ninth Circuit's ruling in both the May and the Wolford case was that they upheld the vampire rule in Hawaii, where they did not uphold the vampire rule here in California. And we kind of speculated as to why that may have been the case. But most importantly here, I'm curious, as we're kind of looking toward the Supreme Court making another big, impactful opinion, and we've been kind of thinking that the next one they were going to take up to do that was Duncan. They take up the Wolford case here, and they say there's some issue with the history, text, and tradition from the Bruen decision, but we're not necessarily going to focus that. We are limiting our scope on the first question here, which is being able to carry on private property open to the public. Why is it that you think they're only trying to address question 1 here?
Because it's, for one thing, it's a fairly simple question, and there is a split now about when a vampire rule might or might not be constitutional. Hawaii's was broader than California's. You could grant someone permission orally. You didn't have to post a guns allowed sign, which is what Ninth Circuit required. And I think they also know that it's an easy way for the Supreme Court to weigh in on the Second Amendment on a narrow issue, and maybe do some things to set the Bruen methodology straight, and to slow some of these lower courts down who are trying to really distort the Bruen decision to uphold unconstitutional laws. But we will be supporting. We did an CRPA and Second Amendment Law Center did amicus briefs on Wolford in the Ninth Circuit in the Hawaii case for them while we were litigating the May case, and we'll do the same thing in the Supreme Court. So we need whatever help folks can give to fund those amicus briefs to try and get that issue resolved. I will say one thing I'm afraid of. Before the New York State Rifle and Pistol Association v. Bruen decision came down, there was another New York case on CCW permits up there, and the state just repealed the law to try and moot the case, and they successfully mooted the case in the Supreme Court. So remember, you've got Everytown Lawyer, which is Bloomberg's law firm, an anti-gun law firm, coaching these states. I'm sure that they are telling Hawaii, repeal your vampire rule so that the Supreme Court doesn't get a chance to address some of these issues.
Yeah, I guess that would be an important fact to remember, as you see a lot of cases go to the Supreme Court that ended up being, well, I wouldn't say a lot, but we have at least seen a couple of them in the recent past, like the one you're talking about, which is good, though. I guess that we still have the May case that's being litigated. We went back down to the federal district court to seek a judgment there, as we've seen that the Supreme Court has been looking for cases not necessarily on interlocutory appeal, but that have judgments that are fully flushed out that way. I am curious, though, in this QP report from the Supreme Court, they identified 2 issues, and they said we're only going to focus on one of them. Is that typical for the Supreme Court to do that? Do we see them doing that in other areas as well, or is this kind of a weird case?
A lot of times they will cut the issues down to the core issue that they really are concerned about, and to simplify the case. But the good thing is they can't really address the constitutionality of Hawaii's vampire rule without explaining the Bruen methodology more, and why the vampire rule cannot stand. They're going to have to get into what comes under the text of the Second Amendment, and then what historical analogs satisfy a modern and justify a modern day law. They're going to have to explain that analysis in order to decide the Wolford case, even with just the one issue. And that's going to help us.
Well, that's kind of where I was going next. I'm sort of thinking about the May case here. I know that they already struck down the vampire rule that California had proposed in Senate Bill 2 from a couple of years ago. Do you necessarily see this aiding the May case at all if we see a good decision from this? And also, can you just explain the difference really quick? Why is it that the Ninth Circuit would strike down California's vampire rule but not Hawaii's? What was the difference between them?
Well, I'll tell you what the case says exactly. Although the state statutes are similar, they differ in one key respect. Judge Grabber, a Bill Clinton appointment, he wrote, Hawaii's law allows a property owner to consent orally, in writing, or by posting appropriate signage on site. California's law, by contrast, allows a property owner to consent only by clearly and conspicuously posting a sign at the entrance of the building or on the premises indicating that license holders are permitted to carry firearms on the property. So it was easier to grant permission under Hawaii's law than it is under California's law. So they upheld Hawaii's law since it was easier.
So do you see potentially a good decision from the Supreme Court aiding the May case as we continue to seek judgment in the federal district court?
Oh yeah, they're going to have to flesh out what is a sensitive place. They're not going to do it all the way. They don't have to go all the way into whether or not beaches or bars or parking lots or any of that stuff is or is not a place where a license can be deemed invalid because it's a sensitive place. They probably won't go one by one, but what they will do is say how you approach the analysis in the context of the vampire rule, and that analysis, even in that limited context, is going to help us in other contexts of sensitive places, and maybe even other Second Amendment lawsuits if they get into what is and what is not a adequate historical analog law that would justify a modern day law.
And where would you think, I mean, where does this leave Duncan? We were kind of looking at Duncan. There was pretty wide consensus through the community. I can't even tell you how many YouTube videos I've watched from other YouTube channels talking about Duncan, talking about how that could be the next big case that the Supreme Court takes and really clearly defines even more what they meant in Bruen. Where does that necessarily leave Duncan in the queue? Does Duncan potentially get pushed down the road? Does it look like they're still going to take it?
I don't think Duncan is going to be granted or not granted certiorari by the Supreme Court based on Wolford. It's going to be, I think it's basically, do they want a pure magazine case, or do they want a semi-auto rifle case with maybe a magazine component? I would like to think that they would like a clean magazine case. It's a narrow issue. But it's still probably the most prominent Second Amendment case on the Supreme Court's docket right now. So we'll have to see what other cases get filed in the Supreme Court as the session's just getting started. The opposition to our cert petition is due, I think, within a couple of weeks. So then we'll just watch what the Supreme Court does. But they may hold it a while. That's what they did last time. They sat on it for months before they GVR'd it, granted review, vacated the lower court judgment, and remanded it back down to the lower court. If Wolford has some good language in it that they think gives direction to Duncan, the lower courts in Duncan, they may do that again. They may say, reconsider your ruling in Duncan in light of what we just said in Wolford.
Needless to say, we will be watching those order lists that come out every Monday now that the Supreme Court is back in session once those last things have been filed to see if they take the case and what happens with that. So I guess, Chuck, just kind of the overall look on Wolford. I got to ask every time, what's the timeline that you see with SCOTUS? What does it look like just as far as them being able to potentially move towards some oral arguments or creating an opinion for the case?
I would expect that oral arguments would be scheduled sometime in the beginning of next year, and we'll have an opinion at the latest in June, if Hawaii doesn't moot the case by repealing the law. But the scheduling has already begun. There'll be the opening brief, the opposition brief, the reply brief, then an oral argument. But that'll all be done this session, which runs from October till June.
Well, definitely something to keep your eye on. We're going to be following along. Guys, we've got some videos to do here. We've got new legislation that's been passed. Perhaps we can take a deeper dive into the NRA lawsuit on the Glock Ban Bill once we've had a closer look at the text there. And as that continues to develop, also there are other opportunities to create lawsuits with the legislation that was passed aside from the Glock Ban Bill. So definitely a lot to follow up on, Chuck. I got a feeling we're going to be seeing you again really soon, but I appreciate your time. Thanks for coming on with us today.
We've got a lot of cases moving through the courts and new ones that need to be filed. The legislature in Sacramento does not give up. They continually try at every level, big laws, little regulations, policies, whatever they can do to make it difficult to own a gun and have a gun for sport or to defend your family in California. They want to do it. And so we've got to keep fighting it. And we can do that as long as we get support from members and donors and supporters who believe in the cause, who believe in what the CRPA is doing. And we are doing a lot. We're winning battles. We haven't won the war yet, but that is coming. We are going to take back all our freedoms in this state.
Absolutely, until the very end. But thank you very much for coming on today, Chuck.
Thanks, guys. See you next time.
Absolutely. And guys, if you like content like this, you want to continue to see the ball moving in the right direction, you can directly contribute by liking, sharing, and subscribing to these videos. It really helps get the information out there. We are trying to get everybody on the same platform of information. Thanks again, guys. We'll see you on the next one.